Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. Later on, we're going to be talking about Jared Polis's press office getting, well, a little Trump-like when it comes to suppressing the press. But first, I want to bring our eyes up to Weld County and the sheriff of Weld County, Steve Reams. Thanks for being here.
Hey, thanks for having me.
All right. Now, you have made national waves on being a sheriff who says, I will not enforce the red flag laws, also known as the Emergency
Risk Protection Order.
Emergency Risk Protection Order, which spells ERPO, which just sounds awful. It sounds like it's some sort of hiccup. All right. For those who don't know, the last legislative session passed what I believe to be a horrific red flag bill.
Correct.
Not because the idea is wrong. There are red flag bills I support, and I think you might be the same. What exactly did they pass, number one, and what's your beef?
Well, so I think when you just say red flag law, everybody understands that to universally mean that it's a law that's intended to go take guns away from someone who's mentally ill. The problem is...
And dangerous.
And dangerous, yeah. Most of these laws don't even mention the word mental ill or mental illness in the bill or in the law that's passed, and Colorado's is that way. It was supposed to result in creating safety for the public, to make sure we didn't have these mass shooters out running around with crazy ideologies. But unfortunately, that's not the bill that actually got passed. So when you read through it and you start to understand what the red flag law is and what it isn't and what it compels law enforcement to do, it really puts law enforcement in a situation where they have to decide, okay, am I going to potentially risk going in and violating someone's constitutional rights by following the letter of this extreme risk protection order law, or am I going to stand with my constituents, uphold my oath, and say, no, I can't do this? That's where I got. I read the law time and time again. They didn't revise it to a way that made sense, and it actually gave my agency so much authority to go in.
Your agency being the sheriff's office of Weld County.
Yeah.
Giving you authority.
It gave me the authority through the courts, if I applied for one of these orders, where I could go in and search someone's home on a civil matter and confiscate their guns when that person hadn't even had a day in court. They wouldn't even know that the incident had occurred.
I want to get into the detail of that, but let's go from the broad part of
Sure.
this first, which is people want to feel safe.
Absolutely.
And I'm convinced with a lot of the gun debate, people don't actually want to be safe. They want to feel safe. And so passing something that's called red flag makes people feel safe.
Sure.
What I have a problem with is, growing up when I did, I was pounded into my head these certain civil liberties that pop up, which is right of due process.
Correct.
And this big one, the ACLU, was always on, you're innocent until proven guilty, that there is a presumption of innocence. The problem with Colorado's red flag law, unlike other states, is this one reverses those things.
Correct.
In that you're assumed guilty, and the presumption is you can't have it. So let me see if I understand the mechanism here. Mm-hmm. If a roommate or an ex-boyfriend, girlfriend
right.
wants to say, this person is a danger. This person is a danger. They have guns. What's the process then? Well,
there's two tracks. So that same person can either go directly to the courts and bypass law enforcement altogether, and appeal directly to the courts and say, and make their case. This person is a significant risk for this list of reasons.
What court, by the way?
Any district court, county or district court in the area that they live in the county in which they live in. So.
And a judge makes the decision based on what, let's say a boyfriend says the girlfriend, she's off her rocker and she's got a gun.
Sure.
She's a danger to others. And the judge says, I agree with you?
If the judge says, I agree with you by what's called preponderance of the evidence, tipping of the scales, over 50%, then the judge signs that red flag order, and he gives that order to law enforcement and says, basically tells law enforcement, go out and notify this person that they can no longer possess a firearm, and they will have a court date within...
Wait. I'm confused. The gun owner, and that's in this hypothetical, the guy's up there saying, my former girlfriend's crazy, I want her to be disarmed. I'm assuming at that hearing, the girlfriend is there too.
You would be assuming very incorrect.
Really?
The girlfriend. This is an ex parte hearing, which means the girlfriend is not there. The person who owns the guns is not there. So when you talk about tipping of the scales, preponderance of the evidence, It's a pretty low standard when the person who's having their guns taken away isn't providing any evidence on their own behalf.
Hang on, because I really want to make sure I'm understanding how crazy this sounds. So, the boyfriend goes to the judge. The girlfriend, the accused, is not there. The accused doesn't get to face her accuser, and he just says to this guy, "Hey, I think she's crazy. Here's why I think she's crazy. Take my word for it." And the judge goes, and every judge will do this. I don't think any judge wants to be on the wrong side of a potential risk and wants to be the judge who didn't take the guns away from somebody, even if it's 1,000,000 to 1 shot, 1,000,000,000 to 1 shot.
Sure.
So he writes up and he signs the order, and then he gives it to somebody like you.
He gives it to the law enforcement officer in the area in which that person lives.
So if the city, it'd be the police. If it's the county, it'd be you.
Right. So that law enforcement officer then goes out and serves the actual order on the person and says, okay.
And is this the first time?
This is the first time they know
the girl
of this.
even knows that she's
Absolutely.
about ready to be disarmed.
So we knock on the door. Hey, congratulations, you're the recipient of a red flag order, and here are the things that you can and can't do. And one of those is that you cannot possess a weapon. So you either have to turn your weapons over to law enforcement, sell them.
Sell them.
That's an option. You can take them to a federal firearms dealer and have those weapons kept until your next court date, which has to be sometime within that 14-day window. At that point, they get to go and now face their accuser, if you will, or plead their case in court. But now the evidentiary level is at a higher level. We're no longer at preponderance of the evidence. Now we're at clear and convincing evidence. To show that either they are still a significant risk to themselves or they're not a significant risk to themselves.
All right, so again, I'm just trying to figure this out. So somebody knocks on the door, says, "Hey, lady, we're taking all your guns," or you can give them to an FFL dealer, federal firearms license, or you can sell them,
right.
which also means going to a licensed dealer mostly.
Sure.
And this is the first time the woman's ever heard of it.
Correct.
And it comes, and she is then disarmed completely for up to 2 weeks. And that's it. So she cannot defend herself if she is someone who needs a gun for protection. She cannot have one.
Correct.
And there's nothing she can do about that until she goes to her real hearing.
Correct.
So she is punished and put into and disarmed.
Yes.
She's disempowered for up to 2 weeks, and then she has to then convince the judge who just said, "I'm going to take away your guns." I've got to prove a negative. I got to prove that I'm not crazy.
Yeah.
And so the negative is, Your Honor, I've got to prove now I'm not crazy, which just flips everything that I learned as a kid about our justice system.
Right. Innocent until proven guilty. In this case, you would be insane until you prove yourself sane. Same concept, though. But I think the part that you have to really focus on here is this is if someone goes and appeals directly to the courts. That gives law enforcement a little authority. We can go serve the order and tell the person you can't own a gun. But I'm not compelled to go search for that gun. It's still voluntary compliance on the person who's having their guns taken away. The more dangerous aspect of this.
Really, so that woman, again, I'm just using hypothetical, you knock on the door, say, "I'm Sheriff Reams, you need to give me your guns." Can she legally say, "Stick it in your ear"?
Well, she could say, "I don't have any."
Right.
She could say, I'd rather turn them into an FFL. I'd rather do I'd rather take a different option. So I don't have the authority to go into her house and look for those guns in that scenario. Where it gets tricky is if law enforcement is the applicant to that red flag order. So let's say that same boyfriend comes into a law enforcement agency and says, "My girlfriend is a significant risk for these list of criteria, and she owns weapons or could own weapons," and they can convince a law enforcement agency to then apply for that red flag order. That adds another level to the whole law, to the law that I think is where people start to get very nervous. And if law enforcement is the applicant, they also will be issued a search warrant, not just to go serve someone with a red flag order, but now go confiscate said guns as well. That's a power that I don't think law enforcement should have, and I don't want.
All right, I've never even really thought about this one, so let me play this one out.
You bet.
Angry boyfriend goes to you and says, she's crazy. Do you have to go get the court order?
So I would basically be going on his behalf. We would
right,
likely go to
right.
court together. I would
right.
use his statement
And
in an
now,
affidavit.
Now, instead of just going there, you actually have the authority to search and seize the guns.
So when I applied for that order, simultaneously I would be preparing an affidavit for the search as compelled to by the law. So I would have to provide an affidavit to do a search warrant of the house, with probable cause now being defined as me being able to say that that female is who we believe she is. She does live in that apartment or that house or wherever, and she does have access to a firearm or could have access to a firearm. That's how probable cause gets defined in this law. They've redefined what probable cause means in every aspect.
I keep saying this. Where are the liberals of the past? Where are the ACLU good guys? And I do mean good guys
Sure.
who go, no, we have Fourth Amendment protections for a reason.
Sure.
And you don't just seize things, and you don't just get a search warrant willy-nilly based on one person's point of view without some sort of probable cause. And it's a different thing
Sure.
for a cop to see probable cause than an angry ex-boyfriend.
Absolutely.
All right, let's go to the hearing then. She's got to prove either way she's not crazy, she's not dangerous, whatever. And if she's not good enough, if what happens to this constitutional right to keep and bear arms? How long does she go without a gun?
Well, that protection order can be issued for up to 364 days from the date of that court hearing. So essentially a year, and then at that year time frame, both the applicant and the person who's affected by the red flag order will be notified that it's about to expire. The petitioner, the person who requested the order, can try to re-up the order yet again, or anyone else can come in and try to do that very same thing, and you can start the process all over. Or it can just expire.
You've taken a stand saying you will not enforce this law.
Correct.
Why?
Well, I kind of hinted at it through our conversation. As a law enforcement officer, any law enforcement officer, we're constantly judged on whether or not we're doing things that are in the interest of our citizens. Are we following search and seizure laws? Are you
overstepping your authority?
Are we That's a great point. Are we overstepping our authority in the way we police our community? And we have tools available to us to deal with people who are in crisis. The red flag law isn't about dealing with a person who's in crisis. It's about going in and taking an inanimate object, and sometimes doing that through force if I'm issued that search warrant to go along with it. I don't see where that helps someone who's in crisis. We have tools available to us to deal with that, and oftentimes we do that now without a red flag law being in place. For me to go to someone's house who might be in crisis, who may be a significant risk to themselves or others, take their guns away, but leave them there.
What's the definition of in crisis in your mind?
Well, in my mind, let's say someone is down in the dumps and they're having a bad day. We've all been there. That person might be deemed to be in crisis by the applicant for one of these red flag orders, but when I go and talk with them, hey, I'm having a bad day. That doesn't mean that the person needs to go be checked into a mental hospital or a mental health hold. They maybe just need someone to talk to. But that red flag order's already been issued. So I'm taking their guns away and saying, well, someone else thinks you're a significant risk. I can't say that I need to take you in for a mental health hold.
Can you tell who said you're a risk?
Yes, it will be provided. There are some provisions where a court can make that anonymous, but that's up to the court to decide.
When this was going through and you became this national celebrity for saying I'm not enforcing the law, because who doesn't want a sheriff to say I'm not enforcing the law? Could they have worded this differently so that you would look at it and go, absolutely, I support this, I will enforce this law?
If there had been
what would they have done?
Well, if you took our mental health hold statute and you modified that, if you were dealing with a person who was in mental crisis, firearms or not, there's probably an argument to be said that if someone is deemed mentally insufficient, mentally incompetent, they shouldn't have a firearm. I think we can all agree with that. If that had been the way that this law had been crafted or drafted, where it said, hey, law enforcement, we understand that some people are in crisis, some people have a problem, and we want to give you a tool to deal with that person in a rapid way, get them the help they need, and eliminate any danger that person may pose on society. Sure, some methodology of that may have made sense, but mental health is the thing that they said they were focusing on with this bill, but it's not even referenced in the bill, other than to give someone potentially some mental health references.
How many other sheriffs have said what you've said? I will not enforce this law because of the lack of due process and the inversion of a presumption of innocence.
Well, there's been a few that have been somewhat vocal. There's probably 4 or 5 that have taken a similar stance as mine, but there's a bunch that have kind of quietly gone along and said, I'm not going to do this. There's 64 sheriffs in the state of Colorado, 62 that are elected. I would guess somewhere in the high 50s are sheriffs that don't support this law and don't intend to use it.
Fair to say you don't want dangerous people to have guns?
Absolutely. Yeah, I don't want a dangerous person to have a gun, but not all people who are dangerous are going to use a gun to commit violence. Not all people who have a mental issue are going to go arm themselves with a gun, and not all people who have a mental issue are violent.
I just worry where this goes over time. When you're short-circuiting due process, when you're short-circuiting this presumption of innocence, when you're having people having to prove a negative, no, I am not crazy, I am not a danger, then I don't want government at any level to have that type of perverse incentive and perverse power. It's something dangerous.
I couldn't agree with you more. And when you look at, it's easy to say this is
whether you love guns or not.
Right.
It's not about guns.
This isn't a Second Amendment issue.
It's about civil liberties.
This is a Fourth Amendment issue. And if you think about how this could impact your First Amendment rights, that starts to go down a pathway that I think the American public isn't ready for. I really don't think this is the conversation that we want to be having a year from now.
Because you express yourself, I might find you to be a danger.
Absolutely.
Sheriff, thank you so much. This has been really enlightening. I didn't know all the ins and outs.
My pleasure.
And thank you for standing up for it. Stay tuned.